judgment, criminal appeal jail 2019.
We have dismissed the appeal. Mr. Goswami, we appreciate your assistance. The court has held that yes, the trial court could not have relied upon the 164 statement.
My lord.
And also his confession before the police was not admissible.
My lord.
But there are other factors
My lord.
which we have recounted. And we say that we also examine whether this case could come under 304 part 2, part 1 or part 2. But we have listed the circumstances for which we cannot do that.
My lord.
He did nothing to save his mother. He was sitting in the veranda, just looking at her dying. Other factors. And PW5 wife, she is totally unreliable. So she has been changing her versions from time to time. Therefore, even her explanation that a mad person came and did it, you cannot assign any weightage to that. Moreover, she is a hostile witness. So let's see now what happens.
DPO next.
But we appreciate all the hard work done by you. Facts are bad.
For judgment, criminal appeal jail 16 of 2019.
Have you pronounced?
We find this appeal to be devoid of merit and appeal stands dismissed. Problem.
I can do 90%.
A bad day for all convicted appellants. You dismiss both the appeals. Yes. Yes.
For eviction, I have 4.
Yes.
Statutory appeal against conviction. He is convicted under section 6 of POCSO Act for 20 years.
We will admit the appeal. This appeal is directed against the judgment dated 31/3/2022, passed by the Learned Special Judge, POCSO, at Golaghat in connection with special POCSO case number 40/2020, whereby the appellant has been convicted under section 6(1). 6(1), is it?
Lordship.
Of the POCSO Act, and sentenced to undergo rigorous imprisonment for 20 years, and also to pay a fine of rupees. Can you tell us the page number where the sentence is there?
Sure.
Fine of rupees 5,000, in default,
Page
to
30.
suffer rigorous imprisonment for a period of 3 months. Stop. We have heard Mr. A. Ahmed, learned counsel for the appellant, and also peruse the grounds taken in the memo to admit the appeal, issue call for the LCF, Stop. Issue notice returnable in 6 weeks since Miss M. Chakravarti, learned counsel, assisting Miss B. Bhuya, learned senior counsel in APP Assam, has accepted notice on behalf of the state respondent number respondent number 1. No formal notice is required to be sent to the said respondent. Full stop. Appellant 2, however, take steps for service of notice upon the respondent number 2 by registered post with AD.
Obliged.
Admission.
Item 5.
May it please your lordship, it's an appeal against conviction, my lord. Conviction under section 302 and 201 of the IPC. My lord. And my lord will find in the appeal memo, my lord, at page 56, the sentence, my lord.
Page 56.
Page 56 of the appeal memo, my lord.
Hmm. How many appellants?
One, my lord.
Take on heard Mr. NBP Sinhala counsel for the appellant. This appeal against conviction is directed against the judgment dated 30/11/2022 passed by the learned sessions judge, Karbi Anglong, Difu, Assam in connection with sessions case number 327/2017 bracket new, convicting the appellant under sections 302 read with 201 of the IPC sections first up. For the offense committed under section 302 of the IPC, the appellant has been sentenced to undergo life imprisonment and also to pay fine of rupees 10,000, in default, to suffer rigorous imprisonment for a period of 1 year. Full stop. For the offense committed under section 201 of the IPC, the appellant has been sentenced to undergo rigorous imprisonment for 7 years and also to pay a fine of rupees 10,000 with default stipulation. Stop. We have perused the interim judgment and have also gone through the grounds taken in the memo of appeal. Full stop. Admit the appeal. Call for the LCR. Stop. Issue notice of motion, not motion. Issue notice returnable in 6 weeks since Ms. S. Jahan, learned APP has appeared and accepted notice on behalf of the respondent number 1. No formal notice is required. State respondent number 1. Respondent number 1. No formal notice is required to be sent to the said respondent. Appellant 2, however, take steps for service or notice upon the respondent number 2 by registered post with AD within a week from today.
The IA is there. I'll file my objection.
So in the IA, right,
I-
so and so for the applicant, Ms. S. Jahan, learned APP Assam place for and is granted 2 weeks time to file objection. Let the matter be listed accordingly. This IA has been filed under section 389 of the CRPC with a prayer for suspension of sentence and also for releasing the appellant on bail. Appellant stroke applicant on bail. Bail during the pendency of the connected appeal.
Obligement.
Item 6.
May
Yes.
please, Your Honor, this delicate application is filed for paying for bail of the petitioner.
You want to file objection?
Lordship.
She wants to file objection. 2 weeks time we'll give. First listing this is.
Yes, that's.
Yes. Heard Miss A. Begum, learned counsel for the applicant. His IA has been filed under section 389 of the CRPC with a prayer for suspension of sentence and also to release the applicant on bail during the pendency of the corrected appeal. This application has been listed for the first time today. Ms. B. Bhuya, learned APP Assam, prays for and is granted 2 weeks time to file objection. Let the matter be listed accordingly.
Item 7.
Item 7, I was supposed to get the medical report. I got it yesterday. He was checked. And then they found, Lordship, this is the report. It's handwritten. 1 page is handwritten, but it's readable.
Show it to her first. What is there in the first? Show it
A
to
lot. Oh. My lord,
I've
others
given
can be
her-
same, my
Huh?
lord. My lord, high BP, my lord, and.
BP is not
My
a
lord,
ground for
200
release. on-
200 by 80, my lord.
You
200
obtain instruction, we'll take it after vacation then.
My lord,
Otherwise, we'll have to reject it because this is the second application.
my lord, the earlier ground, my lord may kindly peruse, my lord, only one paragraph, my lord.
Just give it.
Page 14, my lord, page 14, para 11. Medical ground, my lord, page 14, para 11, my lord, may I be permitted to read the report of the I. While we have my lord, there are other appellants also here. While we have noticed is that Amir Hassan appears to be suffering from certain ailments. We have also noted that he has been given medical treatment by the jail authorities. However, considering the concern expressed by MS by that his condition is precarious, and if proper treatment is not given to him, it may prove fatal to him, particularly referring to high BP, which has been recorded as 180 by 80. We are of the view that the health condition of any inmate must be properly taken care of, and if necessary, bail can be considered on medical ground. However, before we make any consideration, we will require that the said applicant number 1 be examined by Medical Board of Lakhimpur Medical College and submit a report before this court about his health so that the issue of grant of bail on medical ground can be considered appropriately on the basis of such medical report, which may be furnished by Medical Board. My lord, there I take your lordship to page 16, para 19.
Page 16, para 19 of.
My lord, this it's a continuation, my lord. Relevant portion.
Yes.
Accordingly, we close this application granting liberty to the applicant number 1, that is the appellant here, my lord, to file a fresh application along with additional medical documents which he may seek to reply with a copy of the order passed today in this application. Let the medical report be submitted before this court, my lord, after 1 month. My lord, the report was submitted before this honorable court, but my lord, the matter came up before this honorable court on last night, on 9th with one report. We were on 8th, my lord, as his condition deteriorated, again one medical board was constituted urgently, my lord. That report I have annexed at page 22. I got the Xerox copy on application from the jail authorities, my lord, page 22. In which his BP raised to 200 by 80. My lord, then this report,
No,
my
you
lord,
see, the reason why we cannot grant bail, we were asking you to look into the matter and take.
Yes.
But if you are insisting, we'll pass an order.
my
But the
lord,
point
here-
is, earlier, last time when his bail was not granted,
my
the
lord.
BP reading was the same. This time also it is the same.
No, my
So
lord,
we are
it-
left with no option but to
No,
dismiss your
180,
application.
my lord.
Huh?
180 it was.
Hmm.
It increased, my lord, it is now.
Why is it so high? 200 by 80
And
is a high BP.
Because he is suffering from other ailments also like hypertension, that is there, essential hypertension. LVD is one part of the heart is not functioning.
Hmm.
And there is one more lumbar spondylosis and pain in his lumbar. So there are various factors. He is actually going through some deep
So what do you
medical
say
crisis.
to our prayer?
Of course, BP is high on all these three things are there. 200, he's maintaining what jail authorities said is that he's suffering.
Hmm.
So even they are not very reluctant to say that he should not be granted bail and all. They said that he's suffering, he's 70 years of age. He has one part of the heart is not functioning properly. Then BP high, pain in his lumbar, and then hypertension, essential hypertension, 70
But
years.
what is the treatment given to him?
Treatment is given, there are prescriptions, there are, these are there. Lordship can see this. Essential hypertension and lumbar spondylosis has been continuing since October, November. Page 22 is the, my lord, those medications, my lord. My lord, with regard to the medications, I cannot submit beyond my lord. Just I have asked one of my friends who is a doctor. She said these are the last medicines of stroke. He is giving, my lord, that part, tell me some 40 and one medicine named, my lord, amlodipine. These two are given continuously to him, both medicines continuously since 1 month. Since also it's not decreasing. And my lord, he has completely, means he is now on fruit and all those things. If you take rice, he 200 is not decreasing. If 80 is some, if it goes, my lord, then stroke is certain, my lord. And these two, my lord, that part on submission from my lord, I am not sure, my lord, these two medicines are the last medicines to cause before stroke. These two medicines are taken together. And since 1 month, he is continuing, my lord.
And what my learned friend is saying is LVD, I said this is left ventricular dysfunction. This, according to my one doctor, he said one part of the heart doesn't function properly. And one of my learned friend is saying the artery gets blocked. So that
Where
of
does
course,
one find LVD?
My lord, it's in the report.
it's in the handwritten report. Handwritten, the letter. This to the superintendent by the district jail hospital. After lordship, the third line, lordship can see. I would like to inform you that Amir Hassan, 70 years, is suffering from essential hypertension, then comma LVD, then lumbar spondylosis. And he is under treatment, advised by medicine department, Lakhimpur. And there's one more earlier report where it is said PVD, no, hypertension, PVD and lumbar spondylosis. This is in the earlier report. PVD, I've asked, this is circulation problem, legs, blood circulation doesn't go. But there is a block in the blood circulation.
So let him
PVD.
be admitted in the Guwahati Medical College
Yes.
and we'll
He
hear
is
the
in
matter again.
Lakhimpur OPD, he is taken on and off to Lakhimpur Medical
Let him
College.
be brought to the Guwahati Medical College. We'll fix it again on 4th of January.
Lodge,
And you give us a report of his health status.
lodge.
I heard Ms. S. Durwal, learned counsel appearing for the applicant. Also heard Ms. S. Jahan, learned. Yes, Jahan, learned. Or where is he, in which jail?
Lakhimpur jail, my lord.
Lakhimpur
Which is
district.
the
jail.
nearest medical college?
Lakhimpur Medical College, my lord, and hospital. My lord, there only the treatment is going on.
Lakhimpur Medical
And
College.
on the basis of the order of the honorable court, my lord, on last occasion, the team of doctors, around four doctors, my lord, team of 4 doctors is continuously looking after him. But since then, also it is not.
There is an opinion also by the doctor, as his blood pressure is not controlled with medications. Advised by Medicine OPD Lakhimpur Medical College, he is further referred to Medicine OPD Lakhimpur for needful today at 21, that is yesterday. From OPD, again referred to Medicine OPD Lakhimpur.
So let him be admitted in the medical college now,
He was
GMC.
admitted also in GMC, my lord.
GMC.
Long
He
back.
was admitted in, no, Lakhimpur admitted.
Lakhimpur, yes.
Medical college, he was admitted, then again, while
GMC, it will
admission,
be better.
while admission, it went down, then went down to certain extent, it went to 180, 170, then thereafter sent back again.
So this report is from a doctor of the Lakhimpur Medical
My
College.
lord,
Yes.
this is with a team.
Medical and health officer, district jail, hospital, not Lakhimpur.
No, and page 22, that is a report of 4 doctors.
That
The
was a
team.
board.
That
That
the
was
board-
in pursuance with the earlier order.
In pursuance of the honorable court's order, my lord, the board was constituted and the board has taken his supervision twice. First report was.
All right, so GMC, if his health condition permits, otherwise admitted at the Lakhimpur Medical College.
Lodge.
And till such time his hypertension, blood pressure is controlled. And we'll fix it on 4th, you get us a report on 3rd January.
Lodge.
All right, heard Ms. S. G. Barwal and counsel appearing for the applicant. Also heard Ms. S. Jahan, learned APP Assam appearing for the state. In terms of our order dated 20/12/2022, the learned APP has produced a copy of the communication received from the Superintendent of District Jail, North Lakhimpur, dated 21/12/2022, enclosing medical report of the applicant furnished by the medical and health officer of the district jail. Postal. A perusal of the medical report dated 21/12/2022 goes to show that the applicant is suffering from essential hypertension, LVD.
LVD, left ventricular
Disease,
dysfunction.
dysfunction within course of LVD and within course lumbar spondylitis, his blood pressure reading has been shown to be 200/80 mmHg. Full stop. The medical report further summarizes that the patient's blood pressure is not being is not under control with medication, and he has been referred to the OPD of the Lakhimpur Medical College for further treatment. Full stop. Blood pressure of 200/80 is undoubtedly abnormal and may lead to, and if not treated immediately, may lead to further complications. Full stop. After going to the medical report, we are of the view that the applicant is in need of immediate better medical treatment, which can be provided in a medical college hospital of the repute of Guwahati Medical College. Full stop. Therefore, while keeping the bail application pending, we direct the Superintendent of District Jail North Lakhimpur to have the condition of the patient assessed through a medical expert, and if found to be fit, the applicant be immediately shifted to the Guwahati Medical College Hospital and admitted therein until such time his condition is normalized. Full stop. If for any reason it is found that the applicant is not in a position to undertake the journey from Lakhimpur to GMCH, then in that event, he would be immediately admitted at the Lakhimpur Medical College Hospital. A report regarding his current health status be called for and placed before this court on or before 5/1/2023. List this case again on 5/1/2023. Full stop. A copy of this order be furnished to Ms. S. Jahan, learned deputy Assam, for necessary action.
On the of language.
For hearing item 8.
Choose a date after Bihu. We can't take up the matter for hearing.
My lord, this is for bail, my lord. A NIA case, my lord, for bail under section 21, my lord.
Where is the other side?
The name is shown, my lord, in NIA.
Where is the NIA council? Sorry?
I didn't see them since morning. They have not come here. Perhaps they have missed.
Mr. Das, his name is not shown.
Yes, my lord.
We'll have it on third then.
Yes, sir. Showing the senior counsel's name, my lord.
Mr. M.J. Kadir, learned counsel, has appeared for the appellant. However, none has appeared for the respondent, bracket NIA. It appears that the name of Mr. D.K. Das,
Yes.
learned counsel for NIA, has not been shown in the cause list today.
Yes.
Full stop. As such, register to list this case again on 3/1/2023 for hearing as a fixed item by reflecting the name of Mr. D.K. Das in the cause list.
Matter hasn't come on the list. That may be heard along with item number 4.
Yes, but your junior has to act fast.
My,
If I rise after the list is over, then
my,
I'd like to mention these two petitions. These are tender matters, my lord. I pray for listing on 4th of after reopening, my lord. Stay is operating other agencies.
So I take to mention item number 6. May be adjourned for a day.
item 6.
Item 6.
On the prayer of learned counsel for the petitioner, this matter stands passed over for the day. Yes.
Obliged.
May have the some. As breakers, on item number 12, we have filed a document today. Maybe, and we'll have to bring it on record here. So, item number 12.
Yes.
Also.
Daily list for moving.
Wait, please, my lord.
Because the case is that, my lord, the petitioner has land has acquired by the respondent authority, my lord. And thereafter award if in LA case, my lord, declared, my lord. But dissatisfied this, my lord, award, they have filed representation before respondent number 3, my lord. That was pending, my lord. Case 45, my lord. Representation, my lord.
Yes,
Yes, my lord.
you find out whether the representation has been disposed of or not. We'll have it after. huh?
There is a case, my lord, where, my lord, the land has been acquired. Of course, my lord, they are recorded patadas. My lord, their land has been acquired under the provisions of 1964 Act. Now, there are notifications of the state of Assam that although, my lord, lands are acquired under the 64 Act, but the compensation will be given under the 2013 Act. To that extent, they will not be agreed. My lord, the second aspect of the matter is that, my lord, they have filed a representation, but under the provisions of, my lord, section 12, if the person is agreed with the quantum of the awarded amount, he can make a reference to the district court, which they have not done. Otherwise, Lordship may direct, my lord, to dispose of the representation.
No, they have not done because he may not be aware. And second thing, who wants to go to any other court other than High Court? Now the trend is this, the courts are also entertaining. So everything, even declaration of title, dissolution of marriage, everything is going to be done by writ court now. Anyway, heard Mr. Your name, please?
M. Kolita.
M. Kalita, learned counsel for the petitioner. There is the amendments made in the writ petition. The petitioners are aggrieved by non-payment of just compensation for the land belonging to them, which has been acquired by the authorities. First, issue notice returnable in 4 weeks. Since, who is for whom? Mr. A. Bhattacharjee, learned standing counsel, Revenue and Disaster Management Department, Assam, has accepted notice on behalf of respondent number 1.
One, my lord.
You are for?
My lord, one. Only one.
You are for 1.
One.
Acha, Mr. R. Bhattacharjee. And who else? Who is for 2?
No, my lord.
Ms. R. Borwa, learned counsel for respondent number 2, and Ms. S. Sharma, learned government advocate Assam for respondent numbers 3, 4, 5, and 6. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable them to obtain instruction.
I'm so obliged, my lord.
P. Borwa.
Item 2.
On the last occasion, my lord, the lordship had directed them to take instructions.
Yes, no instructions are forthcoming. I've written to them, my lord. Day before yesterday, they have sent an email also, my lord. My lord, on the reopening date, subject to the convenience of this honorable court.
Reopening there. Heard Mr. A.K. Borwa, learned counsel for the petitioner. Also heard Mr. S. Sharma, learned government advocate Assam. He submits that in terms of the order dated 2012-2020 passed by this court, instructions have been called for, but the same are still awaited. In view of the above and on the request of Ms. Sharma, this matter be listed again for motion on 2/1/2023.
Obliged, Diploma.
Item 3.
What's if in this matter instruction was sought from the government?
Yes, what is the instruction?
I think, we've not received the instructions as yet.
2nd January.
Yes, sir.
Heard learned counsel for the petitioner. Also heard Ms. S. Sharma, learned government advocate Assam, who submits that instructions have same order as per 2012 is still away. So list on 2nd.
Item 4.
The same issue, my lord, reopening date, I pray for.
I'm an interim prayer, my lord. My lord, one thing is very essential for adjudication of this matter, my lord. The records of the bidding process, my lord. The records of the bidding process, my lord.
So let them produce the record of the bidding process. We'll have it on 3rd then, not 2nd, 3rd.
My lord, may kindly have it on 9th.
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 All right. What is the other case number, Mr. Sharma?
My lord, other case will be here, my lord. I'll just mention it once it comes. It is only on its way, my lord.
Or you give us the, can you give us the number? We'll put it in this order.
Record to-
I don't have the file, my lord. I'll just give it to you, my lord.
Okay, I heard Mr. R. Sharma, Learned Senior Counsel appearing for the writ petitioner. Also heard Ms. S. Sharma, Learned Government Advocate Assam, who submits that instructions, as called for, as per the order dated 20/12/2022, are still awaited. And therefore, the matter be posted again after the winter vacation. Full stop. Responding to the above, Mr. Sharma, Learned Senior Counsel for the petitioner, submits that the records of the bidding process be called for by this court. Full stop. After taking note of the nature of grievance expressed in this writ petition, this court is of the opinion that perusal of the record of the bidding process would be necessary before passing any further order in this matter. As such, the learned government advocate to produce the records of the bidding process on the next date fixed. Let this matter be listed again on 9/1/2023 along with WPC number so and so for motion as fixed items. Full stop. If the records are fixed item, if the records are not produced, then we'll pass order.
Obliged.
My lord, I may be protected until the 9th, my lord. Until the 9th, the work order may not be given effect to. The work order may not be given effect to until the 9th.
Work order has been issued.
My lord,
So that is not,
my lord,
it has been issued.
it is an issue.
Then you wait. The work order, if any issued to the private respondent shall be subject to further order that we passed in this proceeding on 9/1/2020.
Right.
2023. Yes.
Obliged.
In any case, what will you do in 10 days? What is the work about?
This is my lord, the construction of vegetable shed, my lord.
We'll stop the payment if something appears to be wrong, and your client will get the money. There is a judgment on that. Please find out, get hold of that.
My lord,
The Reliance matter.
my lord. Obliged.
Item 5.
May it please your lordship, this matter relates to the renewal of the premises license, your lordship.
We'll have to issue notice. And
Yes, your lordship.
heard Mr. R. Sinha, Learned Counsel appearing for the petitioner. This matter pertains to the controversy in this writ petition pertains to non-renewal, the decision of the authorities for non-renewal of the pharmacist license of the petitioners.
In spite of the fact that our name has not been reflected in the list wherein the licenses have been cancelled for other
In
purposes.
spite of the fact that the names of the petitioners do not find in the list of those pharmacists
Those licenses been cancelled.
license had been cancelled. Full stop. Mr. A. Chalier, Learned Standing Counsel,
For 5
Health
and 6.
Department,
Lordship.
prays for some time
Yes,
to
Lord.
seek instruction. Prayer allowed. Issue notice of motion returnable on 18/1/2023. Since Ms. S. Sharma, Learned Government Advocate Assam, has appeared and accepted notice on behalf of
Your lordship, 1, 2, 3 and 4, the notice has to go by registered post because they don't have any standing counsel.
since Mr. A. Chalier, Learned Standing Counsel, Health Department, has accepted notice. Correspondent numbers 5 and 6. Yeah, for whom?
Lordship, I can appear, accept notice for all the respondents.
Okay, fine.
Mr. Chalier submits that he has instructions to appear on behalf of all the respondents. As such, he can appear and accept notice on behalf of all the respondents. As such, service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to Mr. Chalier within 3 days. So as to-
Tomorrow.
so as to enable him to obtain instruction. List this case for admission hearing again on this date is 18/1/2023 as a fixed item.
Your lordship, till then we may not be disturbed, your lordship.
Prayer for interim relief will be considered on the
next.
returnable date. What do you want till then?
Till that date, we may, as our licenses has not been renewed, your lordship, till that date, we may not be, because we are not removed from the list. So we may not be disturbed in that date.
We'll inform them verbally, Lordship may not record it in the order, we'll inform them, Lordship, on the next date, if there's some anomaly, Lordship may consider.
Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that no coercive action will be taken against the petitioners without giving them an opportunity to
Lordship.
be heard.
Deeply obliged, your lordship.
Item 7.
Yes.
please, your lordship.
Yes.
My lord, page 49, lordship, earlier this petitioner approached this our report regarding the allotment of details in Lanka Municipal Board, lordship.
So there is already an order from the deputy commissioner.
Lordship, but the
What we do is we post it for motion. Why, can you obtain instruction? What is happening? Heard Mr. K. Majumdar, learned counsel for the petitioner. The basic grievance of the petitioners in this case, of the petitioner in this case, is that despite the recommendation made by the deputy commissioner, Hojai Sankar Dev Never, for allotment of business space. How many petitioners are there?
two petitioners, lordship, two petitioners.
And the petitioners. The respondent numbers 4 and 5 have not taken any action to implement such recommendation. Full stop. Ms. Sharma, learned government advocate Assam, prays for some time to seek instruction and appraise this court as to whether any action has been taken in the matter by the authorities. In view of the above, register to list this case for motion again on 4/1/2023. 2 extra copies of the writ petition correspondence to Ms. Sharma so as to enable her to obtain instruction.
Next date, lordship.
Hmm?
Next date, lordship.
4th of January.
Lordship.
Yes.
I can wait.
Yes.
May it please your lordship, the petitioner has secured some loans from the Canara Bank, lordship, from the respondent bank, lordship. He was unable to pay and in the meantime, lordship, he has preferred an one-time settlement before the honorable bank, lordship. The respondent bank, lordship. Respondent bank has rejected the proposal, lordship. And a BRT proceeding is there, lordship. That is annexure 2.
Nothing can be done.
Yes, lordship. Now, again, a auction notice has been put out, lordship, for the sale of the property. Some time may be given, we are being.
No, you have to talk it with the bank.
Yes, lordship.
What is the amount?
22,67,000.
22,67,000.
Yes, lord.
Deposit 50% straight away.
Yes, lord.
Your lordship, this is the second petition.
Hmm.
And earlier petition we have already disposed of, and our sale is being fixed on 30th of this month.
Go ahead, don't confirm it.
Yes, sir.
Subject to the condition that within 2nd of January, they will deposit 50% of the amount.
We have fixed auction sale on 30th. Your Lord.
That's right, you go ahead with the sale.
Yes, sir.
Don't confirm it, don't disturb his position.
Yes, your Lord.
Position has been taken over.
Symbolic for a position.
Symbolic we have taken.
Don't go for physical disposition or what you call confirmation of sale. You go ahead with the sale, but don't confirm it until further orders, subject to the condition that within 3rd of January, they will pay 50% of the amount due. Otherwise, you are free to go ahead and heard Mr. S.J. Sharma, learned counsel for the writ petitioner. The petitioners herein had availed a secured loan from the respondent bank, but when they had failed to repay the amount, the bank had initiated proceeding under section 13(2) of the Surface Act. Full stop. The mortgage property being the dwelling house. Is it dwelling house?
Lordship, dwelling house and shop.
The dwelling house and the shop belonging to the petitioner have been put to auction sale, and the date of the sale has been fixed on 30th of December 2022. Mr. Sharma submits that his clients are willing to settle the dues if the respondent bank is agreeable to the terms of a one-time settlement. Full stop. Mr. Sharma, learned M. Sharma, learned counsel appearing for the respondent bank, however, submits that without instructions, the earlier round of litigation has ended in failure for the petitioner, wherein similar request was made, but without obtaining instruction. He is not in a position to make any submission. First up, the learned counsel for the bank has, however, opposed the prayer for interim order. First up, having regard to the facts and circumstances of the case, this court is of the opinion that since the petitioner is willing to repay the amount to the bank, one final opportunity should be given to them. Full stop. As such, issue notice of motion returnable on 9/1/2023, since Mr. M. Sharma has accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel, learned counsel for the respondents. Stop. Let this matter be listed again by reflecting the name, listed again on 9/1/2023 by reflecting the name of Mr. M. Sharma in the cause list. First of heard on the prelim interim relief, having regard to the facts and circumstances of the case, it is hereby provided that the respondent bank may go ahead with the auction sale fixed on 30th of December 2022, but shall not confirm the sale till the next date, nor shall they go for physical dispossession of the petitioners from the property till the next date. Now put it here. Confirm the sale not till the next date fixed, subject to the condition that within 3rd January 2023, the petitioner unconditionally deposits 50% of the amount due and payable by them before the respondent number 2 and produce proof of such deposit before this court. If such deposit is made by the petitioner, then the respondent's counsel to appraise this court if the bank is willing to go for a one-time settlement of the remaining dues, and to that extent come up with a proposal on the next fixed. Full stop. That's
Your
all.
Lordship, in case of default, we may allow to proceed as per law.
It is made clear that if the petitioners fail to deposit the amount as directed by this court, the bank would be at liberty to proceed in the matter in accordance with law.
Thank you.
Please, Your Lordship. Your Lordship, the petitioner is a businessman. He is a small-time businessman. He had procured some firecrackers to sell during Diwali, Your Lordship, and he had the license to do that. But unfortunately, due to the rains, he could not sell the firecrackers.
Yes, but unfortunately, today is the last day. We can only say, let him obtain instruction. Nothing can be done beyond that.
Yes, Your Lordship.
Yes. So we'll issue notice.
Yes, Your
In fact, today the license is also not valid. As on date, licenses are not valid.
Yes, issue notice return. Mr. Your Mr.
As they, Your Lordship.
As they learned counsel for the petitioner, perused the averments made in the writ petition. The petitioner is aggrieved by seizure of the firecrackers from the shop of the petitioner, which according to the learned counsel for the petitioner was done without following the due process of law. Full stop. Mr. S. Bora, learned
All
standing counsel GMC,
All that.
prays for 3 weeks time to seek instruction. Issue notice of motion returnable on 18/1/2023. Since Mr. Bora has appeared and accepted notice, all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned standing counsel so as to enable him to obtain instruction, facilitating disposal of the writ petition at this stage of admission hearing. You don't have any interim prayer.
No, Your Lordship. Much obliged.
Yes. Who is appearing in this case? None of us. After timing.
May please, Your Lordship.
What is your matter? Nothing?
I know, my lord.
Huh?
There is
Nothing in it.
probably why have you before your lordship?
Hmm.
As a general country, immediately I have come before lordship. Truly speaking, I also feeling this is a between the two private partners. But what happened? I'm trying for amicable settlement because it is between us.
Try hard.
That is like what happened, my lord. As this amount is deposited in Canara Bank, he is single signatory. Now already some amount has been drawn. I'm not on that also. Whatever bills are coming up. Till that time, if truly speaking, Miller, if this then only I can go. Otherwise, he's not only coming. There is no legal protection.
Mr. Borua, why don't you get a relief for your client? We will not grant any relief. Why
No, I
don't
don't
you
want
get a
today
relief
relief,
from
I
your
don't
client?
want. Today, I don't want, my lord, actually, I'm not at a delivery asking any relief from him also. Only this much already deposited later on little bit, the notices that is issued. Or this much he'll come, otherwise he's not coming. That is only because urgent remedy, because APDCL is
Heard
also
Mr. C.
party.
Borwal and counsel for the petitioner, peruse the amendments made in the writ petition. After going through the statements in the petition, it prima facie appears that it is a partnership dispute between two private individuals. However,
With
after
APDCL.
hearing the submission made by Mr. C. Borwal, learned counsel for the petitioner, this court is inclined to issue notice so as to examine the limited, so as to examine the matter from the perspective of the role of the APDCL, if any, in this case, full stop. Issue notice of motion returnable in 6 weeks. Mr. R.R. Gogoi, Learned SC, APDCL appears and accepts notice.
Response number 1, 2, 3,
Response number
4,
1,
5, and 6.
4, 5, and 6. As such, no formal notice is required to be sent to the said respondents. Extra copies be furnished to the learned standing council, requisite in numbers, so as to enable him to obtain instruction. Petitioner to take steps by registered post with ED by a week for service of notice.
So
in the
today
remaining
actually I'll
respondent.
take this step.
It is made clear that in bracket, this writ petition will be dismissed on the next day.
No,
Not this. I'll strike it out.
But only little protection will not may pay for protection. Because in the meantime, lot.
Protection is dismissal.
No.
Only protection that can be
Please,
given
at
to a
least-
client. All right, Mr. Borwal, enough.
Not that word will not come.
This notice is only for you. Otherwise,
Obliged, Lord. Highly obliged, Lord.
I don't write that one. Certificates are anomalous and have been obtained fraudulently.
Yes.
They will have to file their response. Notice is the only thing that can be done at this stage. Any decision taken in the meantime will be subject to outcome of the writ petition. Heard Mr. M.Z. Raman, Learned Senior Counsel, assisted by Mr. M. Datta. A.M. Datta, Learned Counsel for the petition. Peruse the amendments made in the writ petition. Full stop. According to the petitioners, the tender has been awarded to the private respondent number
10 to 15.
10 to
15.
15,
Amongst others.
based on documents, stroke credentials, which were fraudulently obtained by them. Full stop. Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. P. Bharadwaj, appearing for the. All right, let us finish with them. With the IOCL authorities, submits that that some time be granted to obtain instruction and file affidavit in the matter. Full stop.
Number 10 and 16.
Now say, you convince us, otherwise we'll grant a stay. Come. Why there should not be a stay?
Now, sir, on the same issue,
Hmm.
two earlier litigations are there.
Hmm.
There was a writ petition 374 of 22 that was dismissed, Your Lordship.
374 of 2022.
22, yeah, that was dismissed, Your Lordship.
Hmm.
Agreed by the decision, appeal was made here. The appeal was also dismissed. Appeal number is 4678. Oh, sorry, Lord Lordship.
374.
4678 is the writ petition, Your Lordship. 4678. Writ appeal 37422 is writ appeal, Your Lordship. Our writ petition is 4678 of 22. And thereafter, Your Lordship, the authorities, official respondents have issued letter of authority acceptance, Your Lordship. And that has been almost finalized. Now to prolong the litigation, to stall the process, they are trying to make another issue out of this tender process, Your Lordship. So therefore, it is on the process to the intention of the petitioner is to stall the process, Your Lordship. Tender process. That is that. Because already two litigations have been dismissed, Your Lordship. Therefore, there is no any cause for granting stay of the process, Your Lordship.
All right.
Look, I appear for respondent number 11 and 12, madam. I've received my wakalatnama today, madam. I'll file it during the course of the day, madam.
And you are for Mr. Sharma?
10 and 16.
10 and
There's
16.
there's perhaps some mistake with the cost title. It does not match with the cost title of the writ petition. One party was perhaps deleted, madam. I don't have a copy. I check the record, madam.
Oh, I'm appearing for Azizul Haq and Sunny. They have
Correspondence renumbered, madam.
You are appearing for Azizul Haq and
Sunny. They have Basfor.
Sunnydale Basfor. And what about you?
I'm appearing for Kiran Transport and Prasad Transport, madam. Should be 11 and 12.
Kiran Transport and Prasad Transport.
11 and 12 in the records, madam, but it's.
What about you?
Lordship, I am for 8 and 10.
8 and 10.
My lord.
So both of you are for 10. We'll have to send the matter to arbitration. Yes.
Party number.
Madam, one
8
number
is
and.
second is the government information transport department and 10 is district transport officer.
I am for Azizul Haq. Your Lordship.
Not for the other. Not for Basfor.
No,
She is also for Azizul Haq.
she is not for Azizul Haq.
8 and 10 lordship. 8 is the second is the government information transport department and 10 the district transport officer.
7 to 10.
Achha, all right.
Because I don't have the copy of the petition.
And Mr. Chaudhary, you are for whom?
1, 2, and 3. 1, 2, and 3. I will say.
1, 2, and 3.
I'm for 5 and 6.
You are for?
4, 5.
All right. You right. I heard Mr. M.Z. Ahmed, learned senior counsel, listed by Mr. M. Datos. By filing this petition, the petitioners, numbering in 4, have challenged the letter of acceptance issued in favor of the private respondents, awarding the transport of supplying loading trucks in their favor, inter alia contending that the petitioner, the respondents, the private respondents have bagged bagged the tender by producing fake documents. Full stop. Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. P. Bharadwaj, appearing for respondent numbers 1, 2, and 3, submits that some time is required to verify the statements made in the petitioner and come up with appropriate response. Stop. Mr.
I am for 11 and 17.
You write J. Sharma, is it?
R. Sharma.
R. Sharma, learned counsel, appearing for respondent numbers
11 and 17,
submits that having failed in the earlier round of litigation, that is WPC number 4678/2022, the petitioners have come up with some new grounds, this time once again to assail the tender process. Full stop. According to Mr. Sharma, the instant writ petition is not maintainable in the IF law. Full stop. Having heard the learned counsel for the parties, this court is of the opinion that notice is required to be issued in this case. Full stop. Issue notice of motion returnable on 6/2/2023. Since Mr. Bharadwaj has accepted notice for P. Bharadwaj has accepted notice for respondent numbers 1, 2, and 3. Mr. K. Gogoi, learned CGC for respondent number 4, 5, and 6. Miss M.D. Bora for respondent numbers 7, 8, and 9. Mr. P. Mahanta, Mr. R. Sharma for respondent numbers 10 and 16. Mr. P. Mahanta for respondent numbers 11 and 12. No formal notice is required to be sent to the said respondents. However, extra copies of the writ petition, requisite in numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction. Petitioner takes steps for service of notice upon the remaining respondents. Stop. The question of maintainability of the writ petition is kept open and shall be gone into at this stage of admission hearing.
Only thing, Your Lordship, can the date be postponed? 2nd or 3rd of January?
3rd of
No, February.
February, yes. In any case, the parties have to be served.
Yes.
Then they will come and file affidavit.
2nd or 3rd, 6th, I may not be here.
That's a 2nd or 3rd one. All right.
We may be served copies, Your Lordship.
3rd of February. 3rd of February. All right. 3rd February. Yes.
Only if you may point out, work order has not been issued as yet. And we are continuing.
No, that's all right. We'll see. We'll see.
They may not issue. the
Work order, if any issued in the meantime, will be subject to further orders that may be passed in this writ proceeding.
Because in a similar matter, the CID has been directed to make an inquiry. I've given the order here. But this one.
No, let us see. Let them file their reply. Then we'll see. All right.
Corrected it, then copy may be served to us, the parties that they.
You tell him.
I'll
he
serve
to-
it.
I can 30.
So we can only issue notice at this stage.
Hello.
Heard Mr. M.K. Sharma, learned counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by the proposed move to appoint new dealers in fair price shop.
Not only new dealers, but also curtailment of the membership, my lord. Hopefully some
New dealers in the area, as well as due to curtailment of memberships of the fair price shops. First up, Miss S. Sharma, learned government advocate Assam, 6, 4 weeks time to obtain instruction, prayer allowed, issue notice of motion returnable in 4 weeks. Since the learned government advocate has appeared in accepted notice on the respond numbers 1 to 4. No formal notice, extra copies, full stop steps by registered post to be ready for service on respond numbers 5 and 6.
One small prayer, if possible, when records may be called for, my lord.
They will, let us see first, let them.
Fine.
obtain- Yes.
I'm okay.
I can 14.
Whether relates to settlement of formal and mallet and pending consideration of the application, notice for eviction has been issued, mallet. And in similarly situated case on mallet is examining the matter and the next date is fixed on 25th, mallet.
So you must apply for land under
It is-
Vasundhara. Have you applied?
Yes, yes. we have
Where is
applied.
the receipt?
Yes, yes. mallet. It is there, mallet. That application, mallet will file in page 26.
Page 26.
Yes, mallet.
No. There is an app called Vasundhara.
No,
Is
it was made in the year 2019 itself.
Now you apply.
Because before this eviction notice was already issued, madam.
We'll say that shall not be evicted without following the due process of law and serving prior notice. But you have to apply in Vasundhara, otherwise you are not going to
Even
get it.
encroachment, he says that at paragraph 3, madam.
Yes, he doesn't have title, but he has applied for settlement.
Yes, madam.
Yes.
Now, all of a sudden, how can you throw out
No,
people who are having dwelling
7.5
houses?
letters only, madam.
Heard Mr. J.J. Sharma, learned,
Okay.
J.J. Shekhar, learned counsel for the petitioner. Peruse the amendments made in the writ petition. Full stop. The petitioner claims to be in possession of land measuring 7.5 lechas covered by dag number 12 bracket old bracket close oblique 97 bracket new bracket close, situated at village Ulubari under Ulubari Moja for more than 25 years. Full stop. The petitioner claims to have obtained the purchased the possessory right of the land from its erstwhile possessor by means of an unregistered sale deed and full stop and thereafter constructed a dwelling house thereupon, wherein he is living with his family. Full stop. It is also the case of the petitioner that the GMC has assessed the property and accordingly property tax is being collected. Full stop. Not only that, the petitioner has also applied for settlement of the land by filing application dated 28/1/2019, which is pending disposal before the authorities. Full stop. Notwithstanding the same, there is a move to evict the petitioner from the aforesaid plot of land without following the due process of law. Full stop. Under the circumstances, the petitioner has approached this court by filing the instant writ petition. Full stop. Mr. Saika submits that there is a policy of the government of Assam to allot public settle land with landless persons. And therefore, the petitioner cannot be evicted without consideration of his application. Full stop. Ms. S. Sharma, Learned Government Advocate Assam, raised for some time to obtain instruction. This is also
Similar, my lord.
Huh?
Similar to that, my lord. Regards the same plot of land.
Okay. Issue notice of motion. Similar matters are fixed on 25/1. Notice of motion returnable on 25/1/2023. Since Mr. A. Bhattacharjee, Learned SC Revenue Department Assam, has appeared and accepted notice for respond number 1, and Ms. S. Sharma, Learned Government Advocate Assam, for respond numbers 2, 3, and 4. No formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the Learned Departmental Council. Registered to list this case again on 25/1/2023, along with similar matters, namely WPC number 7383/2022, 7384/2022, and other connected matters. Full stop. As an interim measure, it is hereby provided that status quo as regards the possession of the petitioner over the land in question be maintained till the next date.
For 1 and 2. 1 and 2.
Acha, Mr. A. Bhattacharjee for 1 and 2.
Okay.
At Sharma for 3 and 4. Yes.
Item 15.
May it please your lordship. This is also an eviction matter, my lord. Here the only difference is that the petitioners, they have been living since 1970s, 1980s. And this village was later on, my lord, it was surveyed and it has been carved out as a revenue village. And therefore, my lord, we are entitled to settlement of the land being landless people.
But have you applied?
My lord, we applied, my lord.
Where is the application?
We do not have the copy of the application, but we made in the.
When did you apply?
My lord,
When did you apply?
my lord, we applied 3 years back, my lord.
No, but this portal has been launched only a month back.
Yes, we have not applied it through the portal, my lord.
Unless
but
that
we have-
application is made, nothing else is.
My lord, we will.
Is
do-
it correct? There is an app called
Yes,
Vasundhara.
yes, yes.
Vasundhara,
There
now
is.
it is my lord Vasundhara 2. And here is a case before my lord, where my lord, they are paying Tulsi Bahira receipts. Admittedly, my lord, they are encroachers. They have no prima facie case. This position is not maintainable. Only on apprehended eviction, my lord, they are before this honorable court.
My lord, in fact,
No
yes,
notices, nothing has been served by the administration.
All right, you serve notice and evict. That is what we'll say.
my lord, we were issued notices in November 2021.
Hmm.
And thereafter, we approached the revenue minister also because there was large scale notices issued. Then we were assured by the revenue ministers and the authorities concerned that this has been done by mistake and there will be no eviction in this area because we are long time settlers. Now, yesterday, my lord, after November 2021, now we are in December 2022. Yesterday, my lord, people had come for eviction, and then we mentioned that we have filed a writ petition before the Honorable High Court. So at least this,
No, that's all right. Ms. Goel, you please answer one thing.
my lord.
See, the court will definitely look into if there is a violation of procedural aspects.
My lord.
If people who have some semblance of right are being thrown out without following the due process of law. But if it is the policy of the government that we are going to evict all encroachers, this is nothing for the court to interfere. We are not here to sit in appeal over the government's policy decision.
My lord.
The policy may be right, wrong. The forum is the assembly to fight it out.
My lord,
On
we
what
are-
basis does the court stay all this eviction? We
my-
don't know whether the government needs the land genuinely, why they need, and even if they don't need or don't need, it is for the government to decide.
My lord, we are annual patta holders and 1970s and 1980s, my lord. We have cultivation, now it is harvest time and we are in continuous threat. Yesterday, in fact, they came and just because the writ
We
petition.
will give them stay on 23rd. All these writ petitions are likely to be dismissed on 23rd. These encroachers cannot be protected by order of the writ court.
My
You
lord,
better advise your clients to.
Possible not pass any interim order in their favor because it is an apprehended eviction. They say, my lord, no materials whatsoever.
Oh, you file your affidavit, we'll dispose it off. But at the same time, Mr. Barpujari, you must also address the court. Large number of petitions are coming in these encroachment matters. There is a policy issue here. There is a human rights issue here. Policy issue in the government's domain.
Absolutely.
Human rights issue definitely in the court's domain. So what is the balancing factor you have to tell us?
That is
You
one
have to tell
aspect,
us.
yes. But
We
admittedly,
appreciate that the courts cannot protect encroachers. But all of a sudden, after 30, 40 years, you can't wake up and say that, get out. You will have to come up with some module.
30, 40 years, my lord, they say, my lord, but no convincing materials are annexed to the.
So you file affidavit and tell us that there is no
Will
material.
not protect them in the interim.
No, you can't evict them till 25th,
25th of my lord.
25th of January.
No, those are, my lord, other issues, my lord. Those issues have, my lord, those petitions are springing up, my lord, in view of, my lord, the Suomoto PI, which have been registered by the Honorable Division Bench. Now, Honorable Chief Justice is, my lord, issuing writ of continuing mandamus from time to time, my lord, for eviction of unauthorized persons from government land. But to that extent, my lord, some petitioner, my lord, approach this.
What is the order?
Yes, yes. Possible kindly, my lord. No protection, only, my lord, 3 weeks time has been granted by this honorable court, you vacate. Similarly situated, and I could have understand, my lord, if they have filed any application seeking settlement. They say on one hand, my lord, that for last 30, 40 years, they are inhabiting on this land. Why, my lord, what prevented them, my lord?
No, you said division bench.
Division bench.
Wait, this is not division bench.
No, the division bench, possible kindly, my lord, see the order, my lord. In persons of division bench order, my lord, these petitions were filed. Well, in the district of Kamur Metro, my lord, this PL Suomoto 10 of 2018 has been registered for eviction of unauthorized, my lord, encroachers. Now they.
So you are suggesting that no order to be passed, the government can just go and bulldoze them out of this land. That's what you're suggesting.
No, my lord.
Then
But since, my lord, see, they are making a statement before this honorable court that, my lord, government is trying to, my lord, throw them out without, my lord, any materials. It's a oral statement, my lord.
so you file your affidavit. If there is nothing there, we'll give them at the most 2 months, 3 months time to vacate. That's all and close the
But
matter.
till then, my lord, on what basis, if my lord is giving them protection, my lord, I'm just putting a question, my lord, to myself.
Hmm.
My lord, if stay order is granted, my lord, tomorrow, my lord, they will continue, my lord. It will be difficult for vacation of the stay order. So we do not know, my lord, what is happening. So lordship will, my lord, propose this matter, issue a short notice of motion, my lord. Let us file the affidavit. In the meantime, my lord,
In the meantime, you'll evict.
my lord, no eviction.
It's a wonderful submission, Mr. Barpujari. Wonderful. All right, heard Ms. B. Goel, Learned Counsel appearing for the writ petitioner. Also heard Mr. R. Barpujari, Learned Counsel appearing for the Revenue Department Assam. First up, the writ petitioners, 207 in total, have appraised this court, apprehending eviction from the land under their occupation, which they came to be in possession for more than last
So here, whole difficulty, my lord, in my respective submission is that, my lord, no schedule of land has been mentioned here. Lordship will be, my lord, granting them some interim protection, my lord, what is the schedule of land? Nothing is there, my lord, absolutely devoid.
I've mentioned at page 29.
last last 3-4 decades, full stop. According to Ms. Goel, the petitioners are occupying the land by paying Toji fine, and the government is aware of their position, full stop. The learned counsel further submits that eviction notices served on the petitioners in the month of November 2021 had been withdrawn after accepting that those were served under mistake, and therefore the present exercise is wholly arbitrary and dehoves the provision of law. Full stop. The learned counsel for the petitioner therefore prays for an order of protection from this court. Full stop. Mr. R. Borpugari, learned standing counsel, Revenue Department, Assam, on the other hand, submits that the petitioners are encroachers of government land without having any semblance of right, title, or interest to occupy the land, and therefore they are not entitled to any protection from this court. Full stop. As such, the learned departmental counsel has prayed before this court that no interim order be passed in their favor. Full stop. After going through the averments made in the writ petition, I find that it is the admitted position of fact that the petitioners are in occupation of government land. Full stop. However, it also appears that they are living in those plots of land with their families for past several years. Full stop. Under the circumstances, even if the petitioners are found to be encroachers, even then, adherence to the basic norms of human right and dignity would require that they be permitted some time to vacate the land without causing unnecessary damage or injury to their interest. Full stop. To that extent, this court cannot ignore the concern expressed by the petitioner's counsel. Full stop. Issue notice of motion returnable on, we'll have it on 27th of January.
My lord,
27th.
my lord. I'm so
Don't
grateful.
worry about interim orders. If a case does not have the merit, you are at liberty to mention it. If not anywhere else, mention it here. We'll take
so
up the matter and take it up.
I'm so.
But merely because you find it frustrating that interim orders are there in courts, cases are not being heard, that cannot be a ground for us not to look into a grievance. We have to do justice.
Absolutely. sir.
We are not evicting or not affecting. We are to do justice. We will do that. Yes. 27th of January 2023. Mr. R. Bubuderi, Learned Standing Counsel, Revenue Department, has appeared and accepted notice on behalf of
My lord, R1.
respondent number 1, whereas Ms. S. Sharma, Learned Government Advocate Assam, has appeared and accepted notice on behalf of respondent numbers 2 to 4. Anybody else?
No, my lord. This much.
As such, this writ petition is deemed to be ready as regards service. Extra copies of the petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable them to obtain instruction. Full stop. The respondents may file affidavit bringing their stand on record on or before 23rd January
My lord.
2023 by serving advance copy upon the petitioner's counsel. Full stop. In view of the urgency expressed by the departmental counsel, an attempt would be made to finally dispose of the writ petition at this stage of admission hearing. Parties to come prepared accordingly. Full stop. Till the next date, the respondents shall not disturb the position of the petitioners over the land in question. Full stop. It is, however, made clear that this court does not intend to protect the possession of encroachers over any government land, and therefore the petitioners may be over the government land, and therefore the entire issue will be examined from the perspective of availability of rights of any of the petitioner to continue in the land.
In the meantime, my lord, in the meantime, my lord, with all respect, my lord, if the government so desires, my lord, they can initiate the due process under the law, my lord.
That's not for us to advise.
My lord. I'm so.
I'm grateful.
Yes. What is it? 5 minutes. 2023. So as to enable her to obtain instruction. Prayer allowed. 2 extra copies are given furnished to Ms. Bhakt so as to enable her to obtain instruction. This case again on 3/1/2023 for motion.
My lord, election, my lord, on 25th, my lord.
I can dismiss your matter today if you want. There's no question of granting any interim order. This court
lord.
has been consistently passing these orders. It's good for you.
My lord, only thing is that, my lord, because my lord, this, my lord, register, my lord, pushed some person, my lord, in the election.
We'll examine it. Once the election is held, we'll examine it, but no stay of election. If you want their order to be passed, I can pass it. Want it?
My lord, then, my lord, I have come against their election, my lord, because this election, my lord, they have taken shelter of the, my lord, section 29.
Give me.
My lord, 29, my lord, under how, my lord, he has passed this order, my lord, under 29(4), my lord. There is nothing, my lord, like that, my lord.
Where is the order, page?
My lord, this, my lord, order, impugn order, page 55, my lord.
Yes.
29, my lord. There is nothing, my lord, like that, my lord. But under 29, my lord, without modification, my lord, he can.
Heard Mr. M. Borbaya, learned counsel appearing for the petitioner, assailing the order dated 14/12/2022, passed by the.
And my lord, another, my lord, my rejection of the petitioner, my lord, nomination, my lord, page 53, my lord. Both, my lord.
Page 57.
53 also, my lord, lordship kindly will look, page 53.
Being entirely agreed by the rejection, by the order dated 14/12/2022, passed by the additional register of cooperative societies.
My lord,
Allowing-
they may, my lord, hold this election. My submission is that, my lord, with modification, what he has done, my lord, of the, my lord, notification, let them hold election, my lord. Because, my lord, in the notification, lordship kindly will look, it is clearly prescribed on how to take election, my lord. Lordship kindly will look, there is the notification, page 54, I have translated. Here clearly provided that, my lord, in the earlier board, my lord, those who are disqualified, my lord. As per, my lord, section 44, my lord, they are, my lord, not eligible to contest in the present election, my lord. But it is in spite of that, my lord, in the election, my lord, manifesto, my lord, they have, my lord, page 45, my lord, kindly available. It is, my lord, clear violation of the, my lord, statutory provision, my lord. Page 45, this is, my lord, part of the, my lord, election notification, my lord. Here, my lord, JN, my lord, no member of board of director who are cancelled as per section 44A and 41(8) of the Assam Cooperative Societies Act 2017 will be allowed to participate in election. Next, one of the contestants of the election should present at least in 2 annual general meeting in the 5 years as per section 42 of the Assam Cooperative Society. I am admitting, my lord, this is my election related dispute. Second one, my lord. But first one, my lord, if he has done, my lord, interfered in the election process, my lord, I am entering into the domain of the, my lord, returning officer, my lord. Automatically, my lord, they should have, my lord, change this notification, my lord, and giving chance to all, my lord, he has to do all these things, my lord. And my lord, there is a, my lord, judgment of the.
Okay, Mr. Borbaya, now that's okay. Let's pass the order. Yes, so entirely agreed by order 14/12/2022, issued by Assistant Register Cooperative Society General, permitting the private respondent numbers 7 to 10. They have been allowed to participate in the.
Yes, my lord.
Yes, my lord.
Might be a, my lord, fresh notification.
I'm rejecting that. I'm dismissing your petition.
My lord.
Yes. Respond numbers, allowing as many as 7 persons, including the respond numbers 7 to 10, to participate in the election of the Samabhay Samiti Limited of the Bhaktir Kupa SS Limited, fixed on, election is fixed on 25th of December 2022 on the ground that they were the members of the dissolved BOD and hence not entitled to participate in the election process.
My lord, petition number 2 is the member of the dissolved, my lord, committee, my lord.
Hmm.
And my lord, one my lord is a fresh my lord shareholder. He is rejected. Holding that my lord, he is my lord not present in the two my lord annual general meeting. But my lord, it is my lord apparent my lord, he was present my lord in the two general meeting my lord. This is rejected his my lord. And first, second petitioner my lord, he is the my lord, the member of the dissolved committee my lord. Others are allowed my lord. I am not allowed my lord. This is my lord the case.
So agreed by the notification dated 14/12/2022 issued by the additional registered cooperative societies bracket JEN as well as the notification dated 15/12/2022 issued by the returning officer of Bhatir Kupa SS Limited rejecting the nomination of the petitioner. The instant writ petition has been filed. Mr. Borbhaya submits that the election of Bhatir Kupa SS Limited is fixed on election oblique AGM of Bhatir Kupa SS Limited is fixed on 25/12/2022. And in view of the above anomalies, the election be deferred and the Register of Cooperative Societies be directed to look into the matter. It is the submission of the counsel for the petitioner that the respondent number 3 has allowed ineligible persons to participate in the election process. Ms. S.T. Bhatt, Learned Counsel appearing for the Cooperation Department, Assam, has questioned the maintainability of the writ petition and submits that since the election is fixed on 25/12/2022 and the petitioner has approached his court at a belated stage by raising election-related dispute, no interim order will be passed at this stage. Issue notice returnable in 4 weeks since Ms. Bhatt has appeared and accepted notice for respondent numbers 1 to 5. 1 to 5.
1, 2, 3, 4, my lord.
1 to 4, no formal notice is required to be sent to the said respondent. Extra copies of the writ petition be furnished to the Learned Department Counsel. Petitioner to take steps for service of notice upon remaining respondent by registered post with AD within a week from today, heard on the prayer of interim relief. Considering the fact that the election is fixed on 25/12/2022 and the nature of dispute raised in this petition, I am not inclined to pass any interim order. The prayer for interim order therefore stands rejected. However, the respondent numbers 2 and 4 to ensure that the election process is held strictly in accordance with law. Election of the society is held strictly in adherence.
Maybe election will be subject to the outcome of the
Full. The election of the AGM of the society scheduled on 25/12/22 shall be subject to the outcome of the writ petition.
Deeply obliged, my lord.
debate.
Item 17.
My lord, in this case, my lord, there was some deficiencies of the tender of the respondent number 4. So, my lord, in this present stage, my lord, I said, my lord, the notice may go and let them time the instruction. By this time, my lord, no final decision to be taken.
Lordship is a premature case, my lord. The phrase service is yet to be settled, my lord. In similar matter, Lordship has issued notice of motion and also observed that pendency of the repetition shall not be a bar to proceed further. I have.
Whatever your lordship, I have no.
I heard Mr. P. Montolani, counsel for the petitioner. The issue raised in this writ petition pertains to settlement of number 12 Jatinga ferry service and number 12 Jatinga ferry service and Rajnagar ferry service through online bidding process in terms of NIT number 138 dated 18/7/2022. Peruse the grounds taken in the writ petition. Issue notice of motion return in 4 weeks. Ms. M.D. Bora Leonard SC Inland Water Transport Department Assam has appeared and accepted notice on behalf of respondent numbers 1, 2 and 3 and 4. 1, 2, 3. Therefore, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Departmental Council. petitioner to take steps for service of notice upon respondent number 4 by registered post with AD. Pendency of this writ petition shall not be a bar for the respondents to proceed with the matter in accordance with law. However, order of settlement, if any, issued during the pendency of this writ petition shall be subject to further order that may be passed.
I am deeply obliged.
Item 18.
Also, in this case, the certified copy from the circle officer has not been received by him after due application. So let me get an instruction.
Arrest Mr. Eleventh Counsel for the petitioner also heard Mr. C.K. Borwal and Government Advocate also, who prays for posting this matter again on 4/1/2023, so as to enable him to obtain instruction as to whether, as to the reason why the certified copy have not been furnished to the petitioner till date. Prayer allowed one extra copy of the writ petition be furnished to Mr. C.K. Borwal. List this case again on 4/1/2023 for motion. You are appearing for whom?
For number.
Mr. S. Rama is present on behalf of respondent numbers.
Item 19.
In this case, as per Deputy Commissioner has the power also to amend.
Let him first argue his case.
My lord, here in the petitioner is the absolute owner of a plot of land, my lord.
So these are matters you should go to the deputy commissioner. Why straight away come to the High Court?
So, my lord, the fact hearing is that, my lord, that when the interim order has been passed, it has been very clearly specified in the presence of the my lord, deputy commissioner. They have carried out the my lord, verifications, even though my lord, no any verification has been my lord, conducted.
Will issue notice, that's all.
Fine.
Heard Mr. B.K. Das not counsel to the petition. Agree by the order of cancellation of what? Cancellation of partition.
Cancellation of
Partition of the land belonging to the petitioner. The instant writ petition has been filed, inter alia contending that the respondents have acted in violation of the due process of law. Full stop. Mr. C.K. Borwal and Government Advocate Assam prays for some time to obtain instruction. Stop. Issue notice of motion returnable in 6 weeks. Since Mr. Sharma Guru has appeared and accepted. This is Mr. A. Bhattacharjee, learned SC Revenue, has appeared and accepted notice on behalf of respondent number 1, and Mr. Sharma Guru, learned Government Advocate Assam for respondent numbers 2, 3, and 4. Service of notice is going to be complete in this case. Extra copies of the writ petition be furnished to the learned Government Advocate, learned Department Counsel, so as to enable them to obtain instruction, facilitating disposal of the writ petition at the stage of admission hearing.
Obliged.
Supplementary list, item 24.
May it please the Lord. The petitioners are sought to be thrown out of their own patta land without the government taking recourse to the land acquisition proceedings. My lord, we are the sons and daughters of recorded pattadars of a plot of land. Surprisingly, my lord, without any acquisition proceeding, they have started construction to construct a model college, model degree college over our plot of land, my lord. But we have given representations. We filed an RTI. They have not replied to it, my lord. There's just one reply in the RTI, my lord. They say that no acquisition proceeding has been drawn with regard to our plot of land, my lord. So there's a violation.
Yeah,
of
also
Article
we'll ask
14.
him to obtain instruction first.
My lord, in fact, such instances are not uncommon, my lord. Similar exercise was taken up in in the neighboring districts, my lord. And petitioners in those cases had approached this honorable court, my lord. The honorable court had passed an order of status quo, my lord. In same circumstances.
We'll pass it, but first let him obtain instruction.
Status quo with regard to.
You have to wait till 4th of January.
Some protection.
No, till 4th of January you have to wait.
Construction.
Once he gets,
Construction is going on, my lord.
we'll break it down. They will have to pay compensation to you. What
My lord,
else?
It's our own patta land, my lord.
Mr.
My lord, I understand.
Mahanta, if the government wants to take over any land, the court cannot stop. The only thing that the court can compel them is to pay just compensation if you are the owner of the land.
Exactly.
Why should he stop the
My
construction?
lord, in that case, my lord, the prerequisites under the 2013 Act has to be followed, my lord. There has to be notice So this is violation of fundamental rights as well as my rights under.
Then we'll
300A,
break down the construction.
300A. Lordship, kindly take this order once, since under similar circumstances.
But Mr. Sarma, we have come across cases where forcefully land has been taken over, school has been constructed.
We have to see what are provisions of land acquisition act also followed or not.
Okay, the RTI looks like, my lord, they have said no.
Land acquisition act has to be followed.
Yes, sir.
The government can take over land, can construct, there is no doubt about it. But it can't be done in a
No, it cannot be.
arbitrary manner. You tell us, obtain written instruction. And we will pass more than a stay order, as he is asking.
Let me get the instruction before.
But you have to wait till 4th of January, yes. Yes, heard Mr. P. Mohanto, learned counsel appearing for the petitioner, alleging that the respondents have forcefully taken over the private patta land of the petitioner and have started raising permanent construction thereupon. The instant writ petition has been filed seeking an order of protection. Full stop. If the allegations made in the writ petition are correct, then the same would have to be viewed with sufficient seriousness. However, before passing any order in this case, this court is of the opinion that the learned government advocate Assam should be asked to obtain written instruction from the deputy commissioner of the district responding to the having his preliminary response to the averments made in the writ petition. Full stop. Facilitating the above, this writ petition is directed to be listed for motion a hearing on 4th of January 2023 as a fixed item. 2 extra copies of the writ petition be furnished to Mr. C.K.S. Barwa during the course of the day so as to enable him to obtain instruction. Mr. Mahanta, the court is not declining you the prayer, but once we have it in black and white, we can think of what kind of relief can be molded, even for now. But one thing is for sure, the construction cannot and need not be stopped. Even if the process was not followed, it can be regularized. Your only right is under Article 300A of the Constitution. That will enforce, and there are statutory provisions to enforce.
Specific relief act is also amended, madam.
Sorry?
Specific relief act is also amended. There should not be stay on infrastructure.
That's right.
He'll get that.
This court is
He'll get
not open to staying any infrastructure work. But that doesn't mean a relief cannot be molded. We'll do that. Yes.
He'll get the value of the Jirat, what I'm saying.
Oh, you better give it. You better give it. Give it. Go ahead with the work, but you give him. You can't say that first let us take your land and do whatever we want. Someday when the court passes an order, then we'll. That is an approach which will be difficult to accept. Why is it the IS officers, they don't know what is the law, how that the land has to be acquired, compensation has to be paid.
Notice has to go, objection has to be heard.
We will not stop the infrastructure, but we'll ask the deputy commissioner to come and remain present if we find that knowingly they have allowed the law to be violated. You can tell him that.
Let me get this.
Interim may be considered on the next day.
It is for fixed for motion. Yes.
Deeply operating.
Item 25.
My lord, here the petitioner paid for the remission of the next installment that is due on 1st of January. And the second the refund of certain amount which was he invested under the provisions of 34, 35 and.
So we have to issue notice here.
Yes, my lord. Only prayer is there, my lord. I may be allowed to, give some extension time so that I can deposit the amount. That to be after the,
No, you have come on the last day before vacation.
Because the remission application was there, that is not been considered, and the engineer also forwarded to the document concern admitting all the facts, within the 3.2 kilometer, there is a 4 settlement.
Whatever be the decision, inform him by 30th of December.
Lordship may kindly fix the matter on 3rd of January. I will take the instruction.
On the 3rd of January, I will observe to someone.
It's 5th of January.
No, 6th, because I'll be here on 5th, on 6th,
6th of January. All right. Heard Mr. P. Mohanto, learned counsel for the petition, who submits that his request for extension of the lease And also for depositing the, which this is third
Then-
kiss,
This is the second installment, my lord.
second installment of the kiss money. At a belated stage is still pending with the authorities. Under the circumstances, the petitioner apprehends that adverse action may be taken against him. First of Miss M.D. Bora Leonard, Standing Counsel. This is Forest Department.
Yes, sir, IWC.
IWT submits that before taking any action, the petitioner's request will be considered and therefore she be granted some time to obtain instruction in the
Right.
matter. First of, on the request of learned counsel for both the sides, this writ petition is directed to be posted again on 6th of January 2023 for motion.
My lord.
2 extra copies of the writ petition be furnished to Ms. Bora so as to enable her to obtain instruction.
Must.
Lordship,
My lord, there is a
the
one correction.
petitioner may submit one representation before the director. He has further represented the executive engineer. He is not the
My
authority.
lord, actually, my lord, this has been forwarded by the action taken by the executive engineer, only action is taken. So what is the necessary again?
You
No,
call
sir,
for
I
that,
will-
call
my
for that. Don't make this petty.
No, sir.
you know.
My lord.
You want to give it, you give it. You don't want to
And my lord,
give a reason to order.
my lord, there is a little one of correction of the date, my lord, in page number 10 only. I may be allowed to correct this thing.
I'm deeply obliged.
Must.
Item 26.
Maybe your lordship, kindly this matter will be taken at 2, lordship. Mr. Counsel, lordship at court number.
Let us see
20.
what is the matter.
My lord, petitioners are admittedly encroachers in forest area, my lord.
Hmm.
They claim that there is a process of settlement inside forest, which is, as of now, my lord, today, presently it is not permissible. Under the Forest Conservation Act, any non-forest activity inside a forest has to be concurred by central government. And secondly, my lord, they do not fall under the definition of traditional forest
There
dwelling.
was some other matter like this.
Yes, my lord.
What has happened to that?
One matter, my lord, it has been reserved for judgment, my lord. And I have also received instruction in this case yesterday, my lord.
Hmm.
We say, my lord, they are encroachers. Eviction process is not yet initiated, my lord. So to that effect, my lord, it is premature. And my lord, we are, my lord, constructing a camp for a, my lord, battalion, my lord, in order to protect the disputed Assam Mizoram border, my lord. That has been done with the concurrence of the state central government under the Forest Conservation Act.
Hmm. Yes.
Lordship, sorry, lordship, I have also not having file, lordship. Kindly this matter will be taken at 2.
No,
lordship.
at 2, we can't say. If all matters are over, then it's difficult. Where is the council?
Lordship at court 20, lordship.
Call him, call him. Call him after 10 minutes.
Is another
Wait.
matter, lordship, now going on, lordship.
That we don't know. If he comes before rising, then fine. Otherwise, it will go after vacation. Yes.
Production contest item 1.
No, this is
So it will be
connected-
listed along with that matter.
Item number 4.
List along with item number 4 on, when was it fixed?
9/1/2020.
9/1/2023. You right, I heard Mr. R. Sharma and senior counsel listed by Ms.
P. Fukan.
P. Fukan and counsel for the petition. List this matter along with item 4 on 9/1/2020. Yes.
All right.
Time being matter item 10.
None appears for the, yes,
May it please the lordship. Lordship, kindly the matter may be adjourned for the day and fixed after vacation.
on the prayer of petitioner's counsel, this matter stands passed over for the day. List accordingly. Yes.
Obliged, lord.
Order stayed at evening, item 20.
I'm praying for modifying or vacating the order, which was passed in 2013, Lordship, under different circumstances, because there was a fire during the first part of this month, Lordship, and as a result, 59 families were badly affected. They were homeless now, and we are accommodating them on behalf of GMC in a private bhavan, that is Haryana Bhavan. Whereas the subject matter of the writ petition is that there are 352 numbers of beneficiary in respect of certain dwelling houses under a particular scheme of the central government. 33 are still lying vacant in 2013. So we may be allowed to take over these 33 for the time being to accommodate the fire victims.
Why these 33 are lying vacant?
Because others have already taken possession. And they were all rejected persons. They are either not working in GMC, or there are some non-existent persons, or some are staying in Andhra Pradesh. Their names were given by their relatives.
Achha, the writ petitioners are all rejected.
Rejected.
No, Lord.
We'll hear everybody. Let us first understand what is the issue.
That is not correct.
The list is there, Lordship.
Where is the list?
Page 58.
No,
Page 50.
one thing must be made clear. No adjudication of any right is taking place today. The application of the state is that due to the fire incident which took place 3 days back in, which is that area? Patasil.
Yes, Patasil number on 11th or 10th of this month.
They want to temporarily accommodate the affected persons for some time, and they are seeking the leave of the court to do that because these 33 units are lying vacant. That is the only prayer. It is not a prayer that these people should be settled there. In fact, if the court allows that order, it will be made clear that it will not create any right. They cannot be permanently settled. This will be a temporary arrangement and will be subject to final order in the writ petition. So if you say that no, even if those are vacant and the people are facing difficulties, even then you cannot give it. Then that is the argument. You come forward and we'll see what value to be given. Otherwise, there is no question of determining any right or deciding the writ petition in any manner. That is what the court is not going to do. In other words, the court is not going to deny or reject any claim of the petitioners in both these writ petitions. That is not the purpose. Is that very clear and open?
Yes, Lordship.
That's not the purpose.
It's a stopgap.
If you say that if we don't get it, even then let it remain vacant. But the people in need, in distress cannot still be helped. Then you come up with that argument, we'll deal with it. That's the only point here, no other point. And this will be a temporary arrangement. Insofar as your writ petitions are concerned, we can fix a date somewhere around March and have it finally heard and disposed of. If you succeed in the writ petition, they will all people, the GMC will have to give an undertaking that if the verdict goes in favor of the petitioners, they will hand over vacant position. And that should not be a problem. So that is it. After that, what is that you can argue here? Think about it and do it. That aspect we will not go into today. We are not hearing the writ petition. That's why I mentioned, that is the reason why I'm saying this. The GMC authorities want to use the vacant units purely for a temporary purpose. That is to accommodate the victims of the fire incident as a stopgap arrangement. And they will, of course, the court will say that. Of course, all both the cases, all these 33 units, they will give will record an undertaking. Writ petition number
1/85 of 2019. Two allotments were there. Five, and subsequently, the giving against in the year 2013.
No, Mr. Dasgupta, I'm repeating for the second time. There is no question of your clients getting any allotment today. That is not the proceeding. There is no one from the petitioners is going to get allotment today. Today, the consideration before this court is this vacant units. Whether on the request of GMC, the court should permit them to use it temporarily as a stopgap arrangement to accommodate the victims of the fire incident which took place on 11th or 12th of December. Sorry.
If they entered in the occupation of this, but it will be very difficult to.
That is your perspective,
Paragraph
but if
6
the
of my
court
petition.
says so and if it is difficult, then let that difficulty be there. Once the court makes it clear that the responsibility,
You have stated paragraph 6, Lordship.
after
in
the
the
court order also, if you think it will be difficult, then
We are clearing thousands of bighas of land now from the encroachers. Last 4 lines of paragraph 6. GMC to enable the applicant to make arrangement for temporary accommodation of the families till the new accommodation is arranged to the victim families or final judgment passed in the instant writ petition. Very categorically we have stated. And 13 long years they were not agitating that the matter is to be heard early.
13 years, the corporation and the government was under deep slumber.
Mr. Roy, there is no point in going here and there. I have made it very clear that today is not going to be adjudication of.
No, I will argue only the petition 226 clause 3. Beyond that, I will not.
All right.
Lordship, the present petition IA filed by the applicant, that is respondent number 5, is not maintained in law and fact. Because Lordship, I have filed the affidavit in opposition against the IA yesterday as per the direction of the Honorable.
Is it on record? Has it been called for?
So there is an order that it will be taken to the case in court. Day before yesterday, Lordship passed the order. I filed my affidavit. And in computer shows that it was uploaded. This is my extra copy.
Yes.
Lordship, may be pleased to come to. First of all, before coming to this, my affidavit in opposition, only few facts I would like to place before Lordship. The 30 numbers of the writ petitioner Lordship, they were residing at Hatasil Harijan colony. They are all sweepers and scavengers Lordship. And they had constructed their temporary sheds Lordship, somewhere living in the plastic sheds, Your Honor, Lordship. And then this JNNURM mission came into light Lordship, and thereafter the central government agreed to provide the fund Lordship for the settlement to the urban poor Lordship. And accordingly, the state government level state level committee was constituted, and the GMC is nothing but only a nodal agency for implementing the NNURM scheme Lordship. They are this property or the 3 numbers of building which has been constructed from ground floor to 3rd floor does not belong to GMC. That is the one point. And then their Lordship, the 30 numbers of the petitioners were asked to vacate their their houses from the Patasil Harijan colony Lordship by issuance the notice by the nodal agency, that is the GMC. Accordingly, 30 numbers of the petitioners have vacated their temporary sheds Lordship, and some of them started to reside in rented house, some house in Adabari.
Mr. Roy, please come to the main point. What is?
No, that is related Lordship.
No, that the court is not appreciating. You are going into the background.
Background.
We are not concerned with the background.
background lordship until.
Howsoever strong the background
Okay,
is.
then as I am coming to the
Hmm.
Article 226. Lordship, the article I have quoted in my affidavit in opposition, the provisions of the article 226 subclause 3, Lordship, which is a fundamental right law. And fundamental right, Lordship. Lordship.
So you don't have any answer to his request. You are arguing the written merit means you don't have any answer to his.
No, I haven't, sir.
What is the answer? Tell us
I am
that.
arguing, that I am arguing. Lordship, the order, Article 226 subclause 3 provide that whenever an stay order is granted without serving notice to the respondent or without hearing the respondent in
So
that.
therefore your argument is the court doesn't have the power to accept his application. All right. Next point.
Next point, and the next point is that in this respect, there is a divine judgment of our own High Court. And there are 16 numbers of the Appellate Court decision on this point, Lordship. I'd like to place the division bench judgment of this honorable court reported in 2020. I have given the list of books also, but there the paragraph will differ. So this judgment is based on 16 numbers of the apex court decision, 4 or 5 decisions of our own High Court. But the leading case in this on this Article 226 is Lordship 2025 GLR page 422 Lordship. Here, just I will place the relevant paras. Lordship may come to para 65. There it will be in that judgment, print out judgment Lordship. The relevant para will be Lordship. I have written Lordship, it starts from para 1. On the top Lordship, I have written the paras, first page. In that judgment, it starts probably from 100. Yes, I have written on the first page, para number.
This one?
No, our on High Court division bench, 2020. Because I am having.
What is the name of the party?
Party's name are Lordship. Party's name are Lordship. Kuku Bhoto Ringa and others.
What is the paragraph number?
60 in the DLR, it is para 65, and there it will be most probably starts from. I have written on the top para number of that.
Nothing is written. Nothing.
No, on the first.
Nothing is written.
On the first page of this.
Nothing is written. I have written this just now. Nothing is written.
No, with reading Lordship, it is written.
It is not written. Please have a look. I'm saying it is not written.
No, another judgment, Lordship, there is another one.
Achha, in this judgment, you have written the para number of another judgment.
That's
all right, all right. That's not bad. That's not entirely bad. Innovative things are required nowadays.
So in para 65 of the division bench judgment, this matter has been dealt at length. There it will be start from para 101 or 102. 101 to 102 up to 108. I have highlighted. It is not obligatory on the part of the affected party to invoke this clause 3 of Article 226. There can be a normal application for vacation of any interim order, whether passed ex parte or not. However, this is a special provision and right which is invocable only by a party who had not been furnished a copy of the petition nor given the opportunity to be heard when the stay order passed. I am posing for amendment, Lordship. When the stay order was passed, copies were served to the respondent. Mr. S. Pora has represented the GMC Lordship for the respondent, and after hearing both the parties, the stay order was granted.
All right,
Lordship.
All right.
Thus, this provision has been held to have been incorporated with certain
avoid public purpose of ensuring that ex parte orders do not remain for.
Yes, I have read the entire judgment. Entire judgment I have read.
So this division bench held that no. When the stay order was passed, after hearing both the parties, after furnishing, then it cannot be vacated, modified,
All
or
right.
rescinded lottery. Other judgment is.
Where does it say it cannot be? Where is the word cannot?
That is the ratio of the judgment.
Actually, that is the ratio. That is your interpretation. All right. Next.
The other citation is lordship of the Jharkhand High Court, that lordship, that para 5. Just I will write few lines. From recalling the said provision, it appears that the application for vacating the stay has to be filed by a person against whom the copy of the petition or the document in support of the plea of such interim order has not been furnished and opportunity of hearing has not been given. A bare reading of the provision makes it clear that the party against whom the interim order has been passed without giving an opportunity of hearing may make an application for vacating such order for vacating such order at the earliest possible point of time and not leisurely and with deliberate ease at any point of time. In that case, the court has to dispose of the application within a period of 2 weeks from the date on which it is received. There is thus element of urgency in the provision. It is expected of a party. It is expected of a party against whom an interim is passed. If he so intends to make an application for vacation of the same when he appears at the first instance for bringing his application for consequential automatic vacation of the order under Article 226(3), party cannot be allowed to take benefit of such provision of urgent nature at an stage of litigation. If the party against whom the interim order is passed does not object to the same at his first appearance and does not file an application for vacating the interim order, though files his reply to the contest, the case on merit, the provisions of the automatic vacation of the interim order as in which is in Article 226(3) shall not be available to him, even if the application not disposed of within 2 weeks. So, Lordship, here the order stay order was passed, Lordship, 10 years back in the year 2030. They have appeared in the proceeding and filed their affidavit in opposition. Did not file any application, Lordship. So again, I am coming to the some fact, Lordship. When I vacated the old houses, Lordship, we were assured that they will be given the position within 3 years. The mission JNEURM mission was started in 2005. And the period was given by the central government only for 5 years, which expired, Lordship, in 2010. Lordship, and it is not the property of the GMC, Lordship. They are just the nodal agency, because LOTs will become the absolute honor, Lordship, after paying some prices, Lordship. That is the scheme of the JN. I have annexed that scheme. On some installment basis, they will be allowed to pay, Lordship, and it will be heritable. It is not GMC quarters that they will have any right, Lordship, to accommodate the temporary on temporary basis. Apart from that, Lordship, my learned friend has submitted they have been accommodated in the Haryana. Absolutely incorrect attested. Their own affidavit shows that they have been accommodated nearby Haryana. Lordship, be pleased to pay the affidavit. Lordship, may come to page 30 of the IS, para 5. That the appellant respondent of begs to say that on 9/12/23 untoward incident occurred at Tata Steel GMC Old Colony really complete destruction of the dwelling houses of 59 families, rendering them homeless. Presently, the victim families are shifted to nearby Haryana, not in Haryana, and this nearby land belongs to the GMC. Apart from that, Lordship, in the division bench judgment of this Honorable High Court, it has been held that to pass an order under Article 2263, the petition must show the prima facie case, irreparable loss and injury, a competing balance of convenience loss. There is nothing in the IS because your Lordship knows very well that provisions of Article 226 subclause 3 is nothing but a verbatim of the provisions contained in Order 39, Rules 1 and 2 of the CPC, and also Rule 4 of the CPC, Lordship. Those ingredients must be shown in the IO. That is the finding in the division bench judgment, Lordship. And that's why the matter was again remanded back to the learned single judge for deciding the prima facie case, irreparable loss and injury, and the competing balance of convenience. There is not a single whisper in a sentence, or there is no word regarding the comparative mischief. Your Lordship, be pleased to consider that the present writ petitioners are suffering from 2013. They are without any houses, Lordship, residing in a temporary plastic sets, and see the comparative balance of convenience, Lordship. Who is in the comparative? In whose favor the competing balance of convenience is, Lordship? In the favor of the petitioner. Because fire victims, they are the victim from 9/12. We are the victims, your Lordship, from more than 10 years. Now I leave to your Lordship.
All right. Yes, Mr. Saike, what do you have to say?
So far as this technical issue is concerned, Lordship, that is not applicable because this is an evolving situation. And in a
That's right.
writ court, Lordship, under 226, Lordship has ample power.
So these fire victims were occupying accommodation in the GMC old colony.
Within that campus.
Are these
This is
people are
what
GMC
this is-
employees?
Mostly they are GMC workers, Lordship.
All the affected persons are
All the
GMC?
and the writ petitioners also, who are genuine. Because they have their family members' name also inserted in that list, who wanted to have additional places.
That's all right, but
Yeah.
what I'm asking is,
These are all GMC persons,
you have 59 affected
families.
These 59 are all GMC employees?
Yes, Lordship, yes.
But their
That is why
names,
we are compelled to give them. Otherwise, the whole Guwahati will have difficulties in cleaning the sewerage and all.
Lordship, once their fire victims are accommodated in temporary accommodation, it will be impossible to get it vacated. Lordship, from my childhood, I have been seeing that the sweepers, they throw dead animals inside in the office of the commissioner to fulfill their demand. They what they are not doing, Lordship.
We know how to run our business, Lordship.
Oh, that's why people call it a Guwahati Municipal Corporation malpractice.
I think this is a court of law and you can use the parliamentary words here.
Mr. Royal, is it necessary to go into all these things?
Lordship,
Our dignity is in our hand.
If that has hurt my learner, I'm sorry, I apologize. From my learned friend and from Lordship also. But Lordship, here, the GMC is even not authorized, they have to allot the quarter, distribute the quarter as per the direction of the central government law, as per the JNURM, Lordship.
So you have argued those
Yeah,
points. Mr. Roy, there is no personal interest of anyone in this. We are doing our duty, isn't it? So you have made your point. Why go
Lordship.
below the belt, call names to GMC?
Urban Development Ministry, Lordship, having many flats vacant in the Khelgaon, near Sarsujai, Lordship.
You have filed an application. Have you filed?
No, I have not.
File an
filed.
application, we'll consider. The judges and the court only goes by what is before the court. on
I
the
may be given, not only that, there are many other government.
Whatever,
quarters
we
like-
don't know. We don't know. We have to go around the city with a torchlight at night and find out. How can we find out all these things?
They have sold.
You have a plea to take, file an application. We'll ask the other side to respond, give our decision. That's all. That's how the court is supposed to function.
See, for that some time is required to collect information. what
That you do
government
it.
Quarters are lying with.
That you do.
Matter was listed the day before yesterday. Yesterday I filed my affidavit in opposition. Your lordship is taking
That's
it.
all right, but if there is anything else, if you think that there is any other relief your clients are entitled to, you advise them, and if an application comes, we'll decide it on merit. That's all. That is the
Then
same
also-
standard for his application,
Ur-
your application, everybody's application.
Urban Development Honorable Minister has having more than 1,000 flats lying vacant. But that is his purpose.
That you will know. We don't have access to all these things. Total, there are 352 units,
Yes, Lordship.
out of which 33 are present
Are
lying
vacant.
vacant. And that is because of the court order,
That is because of the court order.
interim order. You want to temporarily use those 33 units,
For accommodating the fire victims.
but the GMC commissioner is willing to give an undertaking that in the event the writ
In
petition
our
is-
affidavit, Lordship may give a direction. What no further undertaking is required.
Right.
That will not do.
It is our,
All right,
in one day, whatever is to be vacated, we'll do it, Lordship. That is assurance from the Advocate General.
All right,
We know how to do our things.
all right. The order will be dictated in the chamber. Anything else you have to say, Mr. Dasgupta?
My case is,
But you will get the order today.
Lordship, highly obliged, Lordship.
for my case is concerned,
You are appearing in 2 writ petitions.
only one. P185 of 2019.
3185 has 2 petitioners.
Two vehicles.
And who is appearing in WPC number 1265? You are appearing.
My allotment orders are there also.
Huh.
Because of this interim order, this allotment order could not be. That is when I approve.
Is that correct? There is allotment order in his favor?
Lordship,
Yes, your lordship.
I haven't gone through the merit of the case today. No, no.
Only 2 times, 2 weeks time. Page number 20.
No, this is not in our brief today. So I haven't gone through the main writ petitions also.
No.
One
Mr.
thing is very clear, Lordship. Why we are saying that we are at,
2030.
they were sleeping for last 7-8 years, maybe more than that. Today, because of the fire on 9th of this month, we filed this application and they are now trying to take advantage of our
1 week time.
anxiety. My humble submission is that we have said that we'll temporarily accommodate because in the meantime, the houses which were gutted can be rebuilt. It is very easy to accommodate. The Lordship has rightly said till March for final disposal. In the meantime, definitely the construction will take place.
We'll fix the matters for final disposal, all the writ petitions as fixed.
Some observation that I will, so my, the allotment orders are there at the.
This is not the subject matter of the IF.
Mr. Dasgupta, why have you not asked for vacation of this interim order for so long? Why? Your client was happy to forego the allotment orders till today. What is the reason? All right, next matter, please. Yes.
Highly
Thank
obliged.
you.
For orders, I think we can see.
Maybe your lordship.
Hmm.
Lordship, the writ petitioner is a society, lordship, registered under the Societies Registration Act, lordship. The Radha Govinda Sevastram, lordship. And that was lordship by the intervention of the.
What is this IA for?
IA for lordship interim order was passed while issuing notice. By that time, lordship, some other persons are lordship restraining the petitioners from entering into the mandir, lordship. So I filed an IA to direct deputy commissioner to help us to enter into our mandir, lordship. We are the society, we are governing body and lordship, we are handling all the matters of the mandir, lordship.
No, but without issuing notice, that cannot be done.
Lordship, already notice was
Lordship,
issued
in regard to
interim.
this, Executive magistrate passed one order. After the lordship, this High Court has passed one order for staying of that order passed by the executive magistrate. Then lordship, in one of the last order of lordship, I think last to last orders, we have been required to get the instructions. The instruction that we have got that after passing of the stay order by this court, we have not done anything in regard to the order that we have passed. But that is the thing. lordship. And secondly, lordship, if it is a registered society, if they have their own constitution to how to elect members, how to have their own meetings. So lordship, in that regard, I think we should not interfere over there until and unless there are some complaints Really complaint. So, first you have to get the instructions. You see. so
They
lots-
have,
so-
they have filed affidavit in opposition.
See, the problem is the only order that can be passed is dismissal of your IA. I'm thinking whether it should be passed now or after the vacation. These are all
Lordship-
private dispute. What the writ court can do.
No, Lordship, the interim order was passed by the executive magistrate. Lordship, the dismissal order of the committee was passed by the executive magistrate, Lordship. That is page 30 of the writ petition, Lordship. So this
Anyway,
is the-
Ms. Chaudhary, we'll see what happens after vacation. Right
Lordship,
now,
only to help the petitioners to run the society. Lordship.
these are absolute private dispute. There is always other version.
You are not interpreting it.
Lordship, private dispute, Lordship, the dismissal of the committee was passed by the executive magistrate, Lordship.
That order has been stayed.
What is the order of the executive magistrate?
Page 30 of the writ petition, Lordship, last page. Lordship.
And the petitioner is your client.
Yes, Lordship.
So you got a stay order. Now what do you want?
Now, Lordship, after the stay order, we tried to enter into the mandir, Lordship. Some other persons are disturbing and restraining the petitioners, Lordship. So, Lordship, we humbly pray before your Lordship to help, to give a direction to the deputy commissioner to help the petitioners to enter into the.
It cannot be done. It will not be done because it cannot be done.
And
That will
Lordship-
amount to interference with.
Lordship, as they have passed this order and taking the benefit of.
Yeah,
the-
why have you filed the writ petition and got the interim order? You have chosen to do it.
Lordship.
There is dispute between two
Until and
sects of the
unless, Lordship,
devotees.
that order was passed, Lordship, we were running
Why don't you
the.
file an FIR?
Lordship,
Somebody-
FIR already filed.
You
Lordship.
file your affair
File, Lordship.
and file writ petition if no action has been taken on the affair. Heard Ms. R. Chaudhary, counsel for the applicant, also heard Mr. C.K.S. Burwal and Government Advocate Assam, who submits that after the stay order passed by this court, the district administration is not in a position to take any action in the matter. Full stop. Since the applicant's counsel has submitted that an order be passed to help her clients to enter the mandir within temple within bracket mandir. It needs to be seen whether such an order can be passed directing the district administration to interfere in the matter. Full stop. However, it will be open for the applicants to take recourse to other remedy permissible under the law.
We may be there.
In view of the above, the prayer made in the IA cannot be considered, same is accordingly dismissed. Next matter, please.
Obliged.
Is for order, I think, 57.
Yes, what is this?
Lordship, the provisional order is there, my lord. Already rooms has been allotted to 5 beneficiaries, my lord. I have already supplied the copy to the petitioner.
You. Right person, man, who has not been allotted vitas earlier. They whimsically allotted the vitas. On the. You can choose matter.
No, my lord. Lordship may kindly go through the.
Just a minute, just a
My
minute.
lord, my
Take your
lord.
seat. Sit
My-
down, sit
my lord,
down.
my lord.
Yes. So, yes,
Madam,
what is that you want?
can we see the standing committee meeting, madam? The executive officer is absent. And only politically,
So these matters, then you'll have to, you got instructions.
Lordship, I have already supplied the instruction, my lord, because it's under Villa Parishad, my lord. They were under video block, my lord, Anchalik Parishad, but this is the constructed by Villa Parishad and already allotted 5 members for 5 chairs, my lord, newly constructed building.
It's whatever was there is already over.
Yes, yes. Lordship may kindly, where is the instruction, the minutes of the General Standing Committee, my lord.
Who has allotted it?
Lordship, the Zilla Parishad, my lord.
madam, can we see?
No, 1 minute, 1 minute. You are appearing for whom? You are-
Panchayat Department.
Who is appearing for the chief executive of?
I am
Zilla?
appearing, my lord.
Then you have to file affidavit and subject to what
My
is
lord,
the
my lord.
response is.
Yes,
My lord.
All right, I heard Mr. Adyapti, like council appearing for the petitioner, also heard Mr. Dutta, Standing Council Panchayat and Rural Development Department appearing for the official respondents who submits that, who has placed a copy of the written instruction obtained from the chief executive officer of Hosai Jilla Parishad, a perusal of which goes to show that the 5 shops, shops constructed
Newly
in
constructed.
the newly constructed market
My lord.
have already been allotted to 5 persons
My
who are not parties to this writ petition.
Yes, my lord.
And therefore, under this, at present, there is no scope to consider the
Right.
prayer of the petitioner. On the request of Mr. Datta, 3 weeks' time is granted to him to bring those facts on record by means of an affidavit to be filed by the respondent number 3.
My lord.
Let the affidavit come, then we'll see.
My lord.
This is the matter accordingly. Yes.
I love you.
Time being matter.
This is the last item.
May it please your lordship. Well, under the particular forest village, we have been there since long. That is admitted position. Earlier also, there was a move afoot to evict the persons. And this honorable court page 31 intervened, recognizing it says, without following the procedure of law.
Mr. Banik, you see, a similar matter came before this court earlier.
Right.
And I think one matter is heard and judgment reserved. If you read the Forest Conservation Act,
Right.
it has a non-obstant clause which supervenes all other provisions. Nobody can, under a statute, occupy forest land. Nobody can. So the only relief that can be given, considered probably is if you want some time to vacate and then take your chance. If the other judgment helps your client, then you will be protected by
I barely understand, but if lordship permits, may I just make a submission on law? I do not say we have a right, but the right to be considered. Under the extant law holding the field India and Assam, the concept of forest village is quite different from village forest. Village forests are different issues under section 29 of the regulation of 1891. But a forest village is something different. This comes under this act of 2006.
All right, Mr. Goswami, which is that other matter where judgment is resolved?
Right now, I don't have, but it was reserved by court number 8.
Court number?
8.
There's a total procedure spelled out.
Then till the judgment is delivered,
Look, my specific instruction is that, my lord, they are in encroachers. Though they are encroachers, we are not evicting them.
no, but on those cases also they are encroachers.
Yes, my lord.
Then let the judgment be delivered in that. It'll be
My instruction says they will not be evicted right now.
They will
That
not be
observation,
evicted.
that observation.
That is already in writing.
All right, I have Mr. S. Banik, learned counsel for the petition. The writ petitioners herein, can you pass on the instruction, please?
Yes.
Are
One more thing, my lord. Just-
in occupation of land which falls within the forest area.
No, it's a forest village.
Are occupying
One-third
land
forest village.
which falls within a forest village, apprehending eviction of the petitioners from the land under their occupation. The instant writ petition has been filed, full stop. Mr. P. N. Goswami, learned additional AG Assam appearing for the respondents, has produced a copy of the written instruction dated 21/12/2022. Comma, a perusal of which, comma, goes to show that there is no move at present to evict the encroachers from the Damchara area.
No, it should be forest, Damchara forest village. Damchara is a huge forest village declared area.
Forest
for
villages,
settlement.
forest villages are inside the forest land. It's not a revenue land, my lord. It's a forest land.
It's a forest land.
Damchara area, including the forest villages
Gotcha.
situated therein. Full stop. If that be so, the apprehension of the petitioners appears to be misplaced for now. However, since it is brought to the notice of this court that another writ petition, you have the number
Yes, ma'am. 4775 of 2020.
being WPC number 4775
Of 2022.
4775 of 2022, raising the same question, has been finally heard by a coordinate bench and the judgment has been reserved. I am inclined to issue notice in this case, issue notice of motion returnable in 4 weeks. Since who is appearing for whom? Since Mr. P.N. Goswami, now counsel has appeared and accepted notice on behalf of
But I will be
Respondent.
taking notice for forest department. Madam. There are
respondent numbers. So Mr. A for taking for respondent numbers 1, 2, and 8. Mr. I. Rafiq R. Ahmed for respondent number 7. And can you please give the name of the others? We'll have to find out. Are you aware who you are
I'm
appearing?
appearing for Madam 4, 10 and 11.
And
madam.
Mr. P.N. Goswami for respondent numbers 4, 10, and 11. No formal notice is required to be sent to the said respondent. Extra copies of the writ petition be furnished to the learned department counsel. Petitioners to take steps for service of notice upon the remaining respondents. By registered post with AD within 3 days from today, awaiting the verdict in WPC
My
number.
lord, may not pass any interim order. My lord, I will ascertain. But in that case also, my lord, I have instructed the DFO not to proceed.
Then
That is
this
my,
case may be
my.
closed on the submission, my lord. Not notice.
So and so, this matter be listed again after 4 weeks in view of the specific assurance given by Mr.
That may not be
Goswami.
recorded, my lord. I will personally, my lord, I will
No,
ascertain.
you can't say that.
No,
Either we will record it or pass an interim order.
The premature
It
repetition.
is not.
Passing
The
an interim
specific
order.
assurance given by Mr. P.N. Goswami, learned additional AG Assam, on behalf of the Forest Department, that the petitioners would not be encroached from the land under their occupation till the next date. I do not deem it necessary to pass any interim order for now.
Well, only thing, my lord, I will be appearing for respondent 11 and 12 also. 12 I have not.
So 11 and 12 also.
Government would take 13 also. Circle officer.
4, 10, 11, 12.
4, 10, 11, 12. Rest of the respondents.
All government officials, my lord. All
So
government.
anything else?
I think that I hope.
Or is this the last case?
It
of
is
the
the
year?
last.
Last case of 2022?
2012.
All right. Best wishes to everyone.